Cairo. They have all given their judgments on different issues that the Court of Appeal is considering, and they have, of course, differed on those different aspects or of course, it will uphold and allow it to proceed. We have Seth Olale, who has been following that as for us, and Seth now joins us. Seth, it could take some time before we get the final concrete judgment on whether the Court of Appeal will uphold or overturn the High Court's decision, Seth.
Exactly, Kiprop. Good afternoon from the Court of Appeal buildings. And like you put it, it's too early to call because these are just 3 judges out of the 7 who have been presiding over the hearings, and today being the D-Day of making that crucial judgment that will decide whether reggae will stop or reggae will be ongoing. And like you said, we've had quite some, judgment from various judges who are presiding over this particular judgment process, which is being held here today. And like you said earlier on, it was the turn of the President of the Court of Appeal, that is Justice Daniel Musinga, just to give an introductory remark as to how this particular court arrived at even now issuing that particular judgment over the BBI. Like we mentioned earlier on, we had speaker after speaker. Those are the judges who were actually now giving those particular remarks. But let's just listen in to some of the issues that were raised by the various judges of the 7-judge bench that is actually issuing this particular judgment. Let's now listen in.
There can be little doubt that formulation of such guidelines will be the business of the Commission, given the critical importance of that threshold in a popular initiative process, and the Commission needed to be quorate. So following a slightly different route, I reached the same decision as the High Court, that IBC was not quorate when it embarked on the business of verifying the BBI signatures on membership of only 3. The exercise of legislative power and the distinction as outlined above is not applicable to the making of a new constitution by a constituent assembly or referendum, because constituent power is not subject to the restraints of any external authority. In other words, the constituent power to frame a constitution is unfettered by any external restrictions and is a plenary law-making power. The power to frame a constitution is a primary power, whereas the power to amend a rigid constitution is a derivative power, since it is derived from the Constitution and is subject to the limitations imposed by the prescribed procedure under the Constitution. And in answer to the very specific question that was posed, whether the constituent power of the people has been argued that for a valid new constitution to come into being, Section 47 of the existing constitution should be amended to provide for the making of a new constitution. This court does not regard these as good constitutional law or good constitutional justice. First, we have agreed with the holding in Joya that Section 47 does not deal with the making of a new constitution or the process of making a new constitution. The power to make a new constitution was not vested in Parliament. It is the amending power that is vested in Parliament, subject to the special procedures concerning the entrenched provisions and also subject to the doctrine of the basic structure. We must also add that Parliament has no right to alter the basic structure of the Constitution.
In my view, the balancing of the rights of a sitting president pose a challenge, as it is difficult to make a demarcation when a president is acting in his personal capacity vis-a-vis his official capacity. Can a president cease to be a president without handing over power during the tenure of his office? In the circumstances of this case, we were told that His Excellency Honorable Uhuru Kenyatta was not the promoter. Indeed, the High Court acknowledged that His Excellency the President was not the promoter, and they coined the term initiator, a term not anywhere in the constitutional amendment process. Be that as it may, the question to be answered is whether His Excellency the President can be a promoter of an amendment bill. In my view, I would liken the situation to that obtaining in the military, where military personnel are often said to be children of a lesser god, to the extent that some of their fundamental rights are limited by virtue of their joining the military. Regrettably, by conduct, there are limitations placed on public officers as to what they can do and what they cannot do. I liken the position of His Excellency the President to that of a judge, where one is a judge 24/7, and it is difficult to say when he or she is not acting in his official capacity. Given the above,
that was Honorable Justice Francis Tuyot, Honorable Lady Justice Fatma Sishale. We also had Honorable Justice Gatembo. We have 4 more to go, including Justice Patrick Kiage and also Honorable Justice Hannah Okwengu, before Honorable Lady Justice Rosalie Nambuya, and finally the judgment will ultimately be concluded by the President of the Court of Appeal, that is Honorable Justice Daniel Musinga. And of course, Kiprop and all our viewers joining us live from the Court of Appeal buildings, we are still camping here and will bring you the detailed judgment right from the 7-judge bench of the Court of Appeal Matters BBI.